And so I'll hit up all of the Niz-Chavez type things that came out. The board issued one in matter of MFO. Not such a big deal. They essentially just agreed with the Ninth Circuit decision, Pozo Sanchez v. Garland, which said that a deficient notice to appear does not stop the clock for voluntary departure. So kind of the same as with cancellation of removal with Niz-Chavez, and the board was just agreeing with the Ninth Circuit. But even the board is in on it now, expanding Niz-Chavez a bit to other contexts. More important than that is the Ninth Circuit's recent decision that I talked about last week on the podcast, titled Cantor v. Garland. And this is the Ninth Circuit one, and this is a big one, almost as big as Rodriguez v. Garland, because what it says is that, so for non-LPR cancellation of removal, you need to have been in the country 10 years continuous physical presence to be even eligible. And then, you got all the elements you need to meet. Cantor v. Garland, so Niz-Chavez says that a deficient NTA does not stop the 10-year clock, okay? And the statute says that the clock for a continuous physical presence stops on service of a notice to appear or the commission of a certain crime. So let's put to the aside people who've committed the crime, because it's usually the service of the notice to appear that stops the clock.
Yeah.
Niz-Chavez said it has to be a compliant notice to appear, and a notice of hearing does not stop the clock. That's Pereira and Niz-Chavez. In Cantor v. Garland, the Ninth Circuit said also a removal order does not stop the clock. So if removal proceedings were initiated on a faulty NTA, and then they were ordered removed, and then they still haven't been removed, as is so often the case, that person has been accruing continuous physical presence all these years, which means that, as was the case in Cantor v. Garland, you have a claim for a motion to reopen based on new eligibility for non-LPR cancellation of removal, if you can show a prima facie case in your motion to reopen. But God forbid you have a very ill qualifying relative, for example, you now have your 10 years, even if you were ordered removed at, say, year 8. If it's been 3 years, you're at 11 years, because the removal order did not stop the 10 years, which is a bit absurd. And Judge McEwen, who wrote Cantor v. Garland, was very clear about that it could be absurd, but the statute is what it is, and the Supreme Court said what it said in Niz-Chavez, and so here we are. So these deficient NTAs are just blowing stuff up in immigration. I think it's going to be a long time that it's going to continue to do so. So that's the recent stuff with NTAs.
Massive amount of attorney legal work just opened up.
It did, and it's also intimidating too, right? Because I can't imagine entering right now and not knowing all of the things I just said, and then you get a client and you miss those issues, and I don't know, is that bad counsel? I don't even know. It's moving from day to day, and that's just one circuit saying, so you're going to have to argue it in a different circuit, and so it's the world we live in. I find it fun, but it is anxiety producing sometimes.
I hear it. It is. It's so that's the ground, yeah.
So that's the deficient NTA issues percolating. So Cantor v. Garland and Rodriguez v. Garland, just monster cases.